What's up, everybody? Welcome back into a weekend edition of The Lawyer You Know. There's just so many updates before we start jury selection next week in Kearney's trial. So I want to give you an update on some decisions the judge has made, some stipulations between the parties. Can they work together? Are they going to agree on certain things? Is it going to give us some insight into some of the information that's going to come in trial two that didn't come in at trial one? And finally, we're going to watch another hearing. Now, you may say, Peter, you said last week was the last hearing, the last pretrial hearing in Karen Reed's case. Well, this was a hearing in another case that affected Karen Reed. Her lawyers show up, her prosecutor shows up, and Hank Brennan's feet are held to the fire, and he has to answer for something that he said in open court that maybe was just completely wrong, or maybe it was just a misunderstanding. So let's take a look and listen now. We're going to start with some of the updates, and then we're going to get to the hearing. So and there's a million updates, I'm sure. I'm going to hit the ones that you guys had questions about. One was the ARRCA request yet again. Hank Brennan said, I can't wait until the middle of trial to get this information on ARRCA. I still don't have what I'm entitled to under Rule 14. They still have not provided me with the information, and in order to have a fair trial, you need to change your ruling. I can't do this questioning of the ARRCA witnesses one day before their testimony, which is going to be in the middle of trial. I need it now. I need a hearing within a week. I need to question these guys. I think Judge Kearney should absolutely deny this motion for reconsideration, basically is what it seems like for Hank Brennan, who's trying to get this ARRCA information. He already has some. He can say he doesn't have anything as much as he wants. We know because he's mentioned it in open court that he has at least some of the information. Now, maybe he doesn't have all of it, but you know what cures that? Another voir dire, another hearing where he asks them all of these questions about what they know, what they don't know, what they spoke about, what bills, how intertwined are they with the defense team, how much are they working with the defense team. He's going to be able to get all that information, questioning them the third time for the Commonwealth, because we had the voir dire trial testimony. This will be a third time before eventually questioning them a fourth time. And the reason Judge Kearney should not reconsider or change this order, in my opinion, is because the defense has moved forward with a million other issues. They're prepping for trial. To throw this wrench in it and make them prep and get their witnesses down within a week while doing jury selection changes their plan for trial. And to throw a wrench in it now, if you make that ruling a week ago or a couple weeks ago while everybody's still prepping for trial, that's one thing. But the defense has moved forward with the judge's orders. And sometimes judges do, especially in the interest of justice, change their ruling if they need to. If more information comes to light and they feel like they need to change their ruling, that's okay. But you can't be a judge who flip-flops, because then it makes it very difficult on the lawyers to prepare and to know that what you say is what's going to happen. And then it also opens the floodgates for motions for reconsideration every time you make a ruling. So that's number one. Number two, the cost to the defense. It's a big deal at this point. The defense has made the judge aware. And while the judge was trying to determine what the right thing to do was with ARRCA, I do think she took that into account. And that's why she said, have them testify the day before their hearing. That's a nominal additional cost for the defense rather than flying them down for an entire separate set of hearings where they have to fly in, stay overnight, prep, testify in court, and then fly back. So I do think she considered that. I think she should leave the ruling in its place. It's going to check all the boxes to make sure this is a fair trial for the Commonwealth as well. And I get it. I get Hank Brennan's complaints. He is entitled to this information based on the judge's order, and he's going to get it. The next update is the judge denied the Commonwealth's motion to redact the means and manner of death. She hand wrote on this order that the ME, the medical examiner, will be testifying. It seemed like Hank Brennan did not want to call the medical examiner. At least Ms. Little said that in open court, that he indicated to them, while she thought he was the medical examiner was not on the witness list, they actually were. But Ms. Little then represented that Hank Brennan said he might not be calling the medical examiner. Why would he not? I think we all know why he might not. The judge wrote in her order that they will be called and they can be examined on this issue. So it's not going to be blocked. Another loss for the Commonwealth. Kind of interesting. I didn't even realize it until, we're talking here together, that it was Brennan trying to get a reconsidered order that on something that he lost. Another motion denied by the Commonwealth. That could be a very big deal, right? Undetermined by the medical examiner. And then you, the jury, are supposed to figure this out and say, oh yeah, absolutely, this is what happened. I think that's a pretty good argument for the defense. And then we're going to get to this hearing where a different judge, not Judge Kearney, held Hank Brennan's feet to the fire. But before we get to that hearing, let's take a look at some of the trial stipulations. And what you do as a trial lawyer, before we actually get to trial, is we try to clean it up as much as possible. We try to only fight about what we absolutely need to fight about. We try to say, let's not make this trial take a million weeks if it doesn't need to. And some of the ways you do that is by stipulating to the authenticity of certain things, stipulating to the admissibility of certain things, and maybe stipulating that you don't have to call records custodians and other things of that nature. Let's take a look at the Commonwealth's pretrial memorandum, and then we'll look the proposed stipulations. So this doesn't mean necessarily that they've agreed to it, but these are what the Commonwealth is proposing. So here's the proposed statement of fact to the jury. On the morning, and what this is what the judge is going to read to the jury as the facts of the case that we can all agree on, and then here's what you have to figure out, members of the jury. On the morning of January 29, 2022, at approximately 6:04 a.m., the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road within their town. Officers responded and discovered the male party, subsequently identified as John O'Keefe, off the roadway in the front lawn area. So it's always interesting, and I always love it. I love doing these because we'll go back and forth on individual words. Where should you put the comma? Is this really what somebody said? Are we going to argue that they said it was 35 Fairview, that they actually gave the wrong address? What are we going to put in here, right? And so to see what they potentially agree on, some important factors. First off, that it was 6:04 a.m., that it was a 911 call. Right? They didn't put his time of death. They didn't put how he died. They didn't put what happened. They didn't put who was there. They said a 911 call called at 6:04, unresponsive male party at 34 Fairview in the lawn, front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. So again, these are facts they agree upon. There's a lot of things they don't agree upon. Did she drop him off? Did he go inside? How much did she have to drink? Who else was there? Right? None of that here is in this stipulated statement of facts. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant, so here we go, the Commonwealth alleges that this is what the jury now has to figure out. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle early that morning and then left the scene, while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies that she has committed any crimes. Now, I was the defense. I would say the defendant has denied that she struck Mr. O'Keefe with her vehicle or has committed any crimes. Or I would say the defendant alleges Mr. Keefe went inside the house and she left without striking him or committing any crimes. Because they have put this detail in their statement of the facts of the Commonwealth, I would ask for the same detail as the defendant, as opposed to, I just deny that I've committed any crimes. Now, the defense could be more vague on purpose to say, well, maybe I could have hit him with the car, but it wasn't a crime. I don't know. Maybe they don't want the jury to have to determine certain facts. I don't think that's what this defense team is going for. So from my perspective, I would ask for a little more detail as the defense to specifically combat the allegations made by the Commonwealth in the stipulated statement of facts. But just so you get an idea of how a lawyer thinks about this, I read what they want and I say, okay, if you want that, here's what I want. We better agree on the facts. But if you're going to put what you allege, there's certain leeway there. I want to respond with what I allege. All right, now the proposed stipulations. The Commonwealth proposes the following stipulations to be entered as evidence at trial. In lieu of testimony by the keeper of records for different institutions where the Commonwealth obtains surveillance videos, the defendant agrees to the authenticity of each video. So this is a complete time saver. The defense would not agree with this if there were legitimate issues with video surveillance. Now, in my opinion, if I'm the defense, I'm not agreeing to anything about the Sallyport surveillance, but maybe some of the other surveillance that was not controlled by the police department, maybe we can agree and stipulate that that's authentic. We'll see. In lieu of testimony, keeper of records at C.F. McCarthy's or Waterford Bar and Grill, the defendant agrees to the authenticity of the restaurant receipts. Again, same thing, supposed to be a time saver, but if the defendant has issues, they do not have to stipulate to this. In lieu of testimony of the keeper of records and in lieu of testimony from any defense counsel. So this is a leverage point, right? They're on the witness list. Why are they on the witness list? Is Hank Brennan trying to get them kicked off the case? No. Is it a bit of a leverage play? maybe. And Brennan's trying to say, don't make me call all these people from Gretchen Voss, Matt Gutman, people from Boston Magazine, ABC News, NBC, Boston 25, et cetera, et cetera. Don't make me call these people. Don't make me call the defendant. Just agree to the authenticity of the audio and video recorded statements that Karen Reed made in all these different interviews and documentaries. Now, maybe they will. Again, time saver. What's going to come in, what's not. But this definitely feels like Brennan plans on using the interviews, the documentaries against Karen Reed in his case in chief, which will be something very different than the first trial. And I think if I was prosecuting this case, I would use them. I was shocked Lally didn't. Number 4, in lieu of testimony by the keeper of records, again, defendant authenticity of the 2-part Vanity Fair article. So articles, videos, documentaries, they want to, doesn't mean they're going to use them. They don't have to use them just because the defendant stipulates this. This is purely a time saver. And from the defense's point of view, Brennan's like, well, then I won't have to call you, Mr. Yannetti, to confirm that this happened the way we said it happened, because there you are on video and being recorded. The parties agree that the known DNA standards for John O'Keefe may be admitted without testimony from a forensic scientist that created the standard. The parties also agree that the standard may be used and referenced by analysts from the Massachusetts State Police Crime Laboratory, Bodie, and UC Davis Veterinary Genetics Lab when they testify to their work, analysis, and conclusions based on samples in this matter, including making statistical opinions based on the standard for John O'Keefe. I feel like, and again, memory's a little hazy, I feel like the defense argued a little bit with that with some of these witnesses, so I don't know if they are stipulating to this or just this is the Commonwealth's proposed. I think the defense is going to take some issue with these. I don't know if the defense has filed proposed ones, but these are the questions you guys had was based on these. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of her medical treatment records and medical treatment records of John O'Keefe and the admissibility of such records subject to appropriate redactions. In lieu of the testimony of the records, keeper of records, the defendant agrees to the authenticity of reports generated by the Canton Fire Department. In lieu of the testimony. So the other thing that's kind of dumb about these is so many people are testifying that could testify that this is the way they keep records. But in lieu of testimony from Aiden, from Andy Klain, and Mike Maroli, the defendant stipulates that the September 23rd, 24 Aperture LLC inspected, photographed, measured, and laser scanned the defendant's 2021 Lexus, John O'Keefe's 2019 Traverse, and the area outside of 34 Fairview, the driveway surrounding the area of 1 Meadows Avenue, where were photographed and laser scanned. So this is to do with the experts. Again, I don't know whether the defendant has already agreed to this, or maybe they will, maybe they won't. Additionally, the Commonwealth proposes when questioning witnesses for uniformity and efficiency, the parties agree to use the transcripts from the prior trial that do not contain the sidebar conversations. I'm interested in how they're going to do that when they impeach. You testified at a prior hearing in this court is usually what they say. They usually don't say, or I should say in a trial when there is a second trial, we don't say you testified in the first trial to let this jury know there was an issue with the first trial. Maybe there was a hung jury. Maybe that puts in their minds, well, maybe we'll just be a hung jury. You want to avoid all that. And usually you say at a previous hearing, you were sworn under oath, et cetera, et cetera. All right. Now let's get to this hearing, which centers around a couple issues. And the issues that it centers around, frankly, are the Turtle Boy case and the dissemination of privileged information. Both sides don't want this going back and forth. Both sides seem to be worried that it's happening by the other side. And there were some issues about what Hank Brennan said in a prior hearing and representations he made to the court about what was in these text messages and communications between Turtle Boy, Karen Reed, lawyers involved. What did he assure the court of? And is the court taking issue with that? And how will Brennan explain himself? Let's watch, because this is very different than Judge Cannoni's courtroom, I would say. You guys let me know if you agree or disagree in the chat, and hit that like button if you haven't already. Take a second, hit the like, subscribe. Let's get to it.
Doesn't seem so. Okay. Folks, we are here on 2 related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that
By the way, this is why it's important to have to file affidavits with these motions, because if it's wrong, the court has it right there in writing and you can't squirm about it. And you can't say, well, I actually went back and listened and what he said is not true, but I'm not going to get into it. No, this is why you either have to put an affidavit here in this jurisdiction or say it in open court, write it in a motion so the court knows exactly what you said.
Quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement,
Representations have been made about a joint defense agreement.
Specifically inquired of you, Mr. Brennan, at the hearing on this matter last week. Do any of the 3 categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these 3 articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that 1, there are in fact a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications. And in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel.
Uh-oh. The 2 special prosecutors don't seem to agree with each other. Somebody said something that was not correct to the court. Let's talk about this misunderstanding. And frankly, misunderstandings happen, right? It happens, but Brennan should have to explain himself when he says something that is not true and turned out to not be true.
And as such, if that is the case, and we did understand each other, I can simply clarify my order for special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
I think there are 2 separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Bettero and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
It's like, wow, I misunderstood that to mean Mr. Kearney's attorneys. It's like, the judge is like, that's why I clarified, Mr. Brennan. And I like how he doesn't just say, okay, fine, let's move on, but he pushes and he says, but why, but how? And this judge has done that to both sides, which is what I like. Be consistent as a judge. Treat both sides equally.
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Bettero.
Okay, well, we all agree, counsel, that those in fact would be privileged communications without.
Duh. Like, you don't have to say that. That's the point. We don't have to argue about whether or not, well, maybe with Hank Brennan you do, right? After recent motions trying to get conversations between Yannetti and Karen Reed. But there are reasons for that. But maybe somebody could have misunderstood him to be asking for conversations between Kearney and his lawyers. But seems pretty clear from this judge, that's not what we were talking about.
Question. So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Bradel responded, well, it's a little more complicated because we know he's under investigation along with Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so
Exactly, which means you should have known it.
I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless I'm pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date, but those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth pleading that there is, in fact, information demonstrating that the lead team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So that's Turtle Boy's lawyer, Brandel, on the phone in the hearing, arguing no, Judge. And it seems like the judge and the defense lawyer are on the same page here. That's why the judge kind of smirked.
Okay.
So we are not asserting that. There's no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only...
He's right. For example, if Turtle Boy wanted to say something to Yannetti, what does that have to do with Reed's consciousness of guilt? And how would they be able to use that against Reed? So to me, that doesn't make sense why that would be discoverable in Reed's case. Again, we got to keep all this separate. It feels very convoluted. I know people have their thoughts about it, but legally speaking, we're focusing on the rules, the relevance here. What can they discover first? Then will they even be able to use it at trial? But why would they be able to discover things that don't show consciousness of guilt for Karen Reed? That is what the order is limited to, not witness intimidation.
Communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you right there, Attorney Bradel, because you raised an excellent point. And that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Kearney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an expressed conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need.
You can hear the almost sarcasm or doubt in his voice, but that's why all this stuff needs to be separate. They can't be working together. They can't be sharing information, just like the defense attorneys are not supposed to be sharing confidential information, but the defense attorneys can talk strategy. They can talk with each other about, what's this witness? What do you think this witness is going to say about Turtle Boy or whatever it may be? They're allowed to talk to each other in a different way than the prosecutors are because of the conflict and because of the separation that's supposed to be in place.
Need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated and in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank you.
So the fact that
Attorney Brennan,
So he says nothing should be turned over based on your order. The way your order limits the communications, the defense's reading of the text messages and everything involved, nothing should be turned over, which means Brennan would have nothing to use at Karen Reed's second trial if Attorney Brandl's correct.
I'm going to ask you to pause for a moment, and I'm going to hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if
No. If Ms. Reed's attorneys say, see if you can get information on this witness, or see if you can prove somebody else was at 34 Fairview. Let's just say that's what they said, right? I have no idea what's in them, obviously. But if they said, see if you can find anybody else that was at 34 Fairview. See if you can find anybody else that says this witness is a liar. See if you can find somebody else that says this cop covered up a crime, right? The prosecutors can try to say, oh, that's because Karen Reed did it, and they're just trying to find ways to distract. No. Defense attorneys specifically look at every argument, every angle, regardless of what their client tells us, because sometimes our client tells us, it wasn't me. I don't know how to prove it wasn't me. So then defense attorneys are like, okay, let's go with time. Let's go with opportunity. Let's go with location. Let's see if there was any other third parties. See if there's anybody else with motive. And we try every different way to try to figure out what happened, especially if we have a client who was like, I wasn't even there. I'm not saying that's what happens in this case, but I wasn't there. But they're saying I was. Well, how do you prove something that is an absence of something that happened? So sometimes we ask all sorts of questions, which is why we're allowed to have alternative theories as criminal defense attorneys, attack it from different angles, argue reasonable doubt, bad investigation, and third-party culprit. You're allowed to do things like that. So to say everything a defense attorney may ask for can show consciousness of guilt for their client doesn't make sense to me.
one reads the the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney.
Now, if it says lie and say I was never there, or lie and say I didn't hit him when I did hit him, obviously that would be important communications to turn over. According to the defense, that's not what we have here.
I think that they act together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Well, I will, of course, comply with Your Honor's order.
Thank you.
But
Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Brado. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Brado. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. I am not, this is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you?
Why do we need this, right? This should already be in place. Karen Reed's judge has already put an order in place to not allow them to share this information. And Brandel's explanation of what's going on is basically, we don't trust it. We want an extra layer of protection, Judge. Again, this is highlighting what these defense attorneys are trying to highlight in the case is they do not trust the Commonwealth.
You request?
They are, Your Honor. Judge Kearney specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibits, Judge, that these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Kearney's suspenders?
I think so, Judge, because we need one. And we need one as to this.
And the reason for that analogy is suspenders already hold up your pants. So why do you need a belt? right? You ever seen somebody with a belt and suspenders? He's like, why would I need a belt if we already have suspenders? And Attorney Brandle's like, the pants are still falling down, Judge. That's what we're worried about.
Specific information. These three people have repeatedly stated that they're privy to inside information. And with respect to Mr. Kearney's information, but although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these two different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Kearney. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Kearney's order didn't work either based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these three people must stay away. And in general,
he focuses a lot on people intimating that they have certain information and it seems like leaks are happening and there's these vague kind of comments that are made, and that just needs to be shut down. That needs to be stopped. And to me, the judge seems a little sympathetic to this. I don't know if it's based on the comments he made at the beginning of the hearing to hang Brennan, but he's like, okay, better safe than sorry. Basically, it's not impossible that two prosecutors, law enforcement, special prosecutors may have accidentally or talked about something they should have. So let's put an extra layer of protection on here. He's not scoffing and offended that Attorney Brandle would ever assume something like this could happen, which I think is kind of how a judge should be.
Order as well as part two is my part two. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be ground for a live hearing with sworn testimony about these leaks.
Understood.
So
Okay.
that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brandle. Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, et cetera. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. Again, detailed, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, 88 Cosgrove, Special 88 Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
We have a freeze here.
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday. And if you encounter any difficulty or challenges in doing that, just please let the court know and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between special process.
So Brennan again is getting up to defend himself, defend his honor. There have been no communications between he and Cosgrove, he says.
Just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
I'm the one that's ethical, Judge. It's me. And he's right. He is the one that filed that motion, and those are the reasons, but it exists. Brandel didn't say we filed the motion. Brandel just cited some, and so did Yannetti, some specific things that Cosgrove had done that they take issue with that the judge needed to be aware of. But Brennan, that was a funny pound your chest moment a little bit from Brennan. He's like, after I got kicked earlier, Judge, I'd like to stand up and defend my honor.
Understood. Thank you, Attorney Brennan. Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now. Thank you, counsel.
Thank you.
And he doesn't let Yannetti or whoever that was, I think it was Yannetti, even respond to what Brennan just said, which isn't, in my opinion, the best thing to do. If you're going to let Brennan just get up and say that for the record, you should let a brief response and then end it. He didn't allow it. I think he didn't allow it because it wasn't going to change his mind. It wasn't going to affect him. If it was something that was going to affect him, he would have given Yannetti the opportunity to respond, but that wasn't the case here. Oh man, this thing is just never ending. We thought we had the last hearing and we have another hearing that affects Karen Reed's case. We thought we had the last couple filings. I can guarantee you filings are going to be flooding in during jury selection. They're probably going to be having hearings during jury selection. We will follow all of it. You guys have questions, hit me up on Twitter at LawyerYouKnow. Hit me up on Instagram at Tragos Law. As you have these questions, we will make sure to get as many of them as we can answered. Make sure you hit that like button on this video, please, and subscribe to our page. But until next time, that's all we got. So I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.